Now that we've covered the basics of definitive documentation and what these agreements are, it is time to move on to figure out how are these documents actually drafted and negotiated upon. In real life practice, you will be given a term sheet on which the definitive documentation can be built. Now, of course, we've discussed how the term sheet is not binding, but the definitive documentation will act as a binding agreement or set of agreements. So typically we build upon the term sheet where the basic terms and conditions pertaining to the transaction already exist. Parties have some idea as to what rights and obligations they will have. But now that we have also completed our due diligence project, we then apply the risks, we apply the allocation of risks to the term sheet to make it into a definitive document, whether it's a share subscription agreement or a share purchase agreement or a shareholders agreement. Now, within all of this, you will have a format to go by. Different firms have different formats of each of these agreements, and it's not unusual for lawyers or for M&A lawyers to simply copy paste entire chunks of text, terms and conditions and obligations from one agreement to the other. I encourage you to do the same. However, please make sure that when you're copy pasting from an existing format, that you read it thoroughly to ensure that there are no exogenous terms that have not been agreed to that are coming in. So effectively, term sheet plus the due diligence report plus the format gives you the definitive documentation. Now, in any agreement, no matter how complicated, there seem to be 6 elements. Now, this theory of 6 elements draws heavily from the work of Michael Klausner, a professor at Stanford Law School. I had the opportunity of meeting Professor Klausner many years back, and we discussed this in some detail. These 6 elements are the exchange, pre-transaction information asymmetry mitigation clauses, regulation of post-contract conduct, asset-specific clauses, exogenous risk mitigation clauses, and jurisdiction clauses. These 6 elements will make up any transaction or any agreement anywhere in the world. Let's start by explaining what these elements mean. To begin with, the exchange. Now, the exchange defines or talks about the very basic elements of the contract. Who are the parties? What is the background to the transaction? What asset is being traded? Is it a share? Is it a convertible debt? Is it a convertible preference share? At what price is it going to be traded? When is the trade going to happen? Is it going to happen all at one go, or in parts, or in tranches? This is the first element of any share subscription agreement, the exchange. This sets up the very basic foundation of the transaction. But we all know of this term we call buyers beware, right? There's another economic reason for caveat emptor or buyer beware. The reason being that the seller of any good, whether it's a share or a movable property, will always have more information about that good or that asset than the buyer will. The reason for this is the seller has been in possession of that good. Think about buying a second-hand car. When the first question that you will ask when buying a second-hand car is that, why do you want to sell it? So automatically you're asking, is there something wrong with the car? This presupposes the fact that the seller of the second-hand car will always have more information about that car than the buyer. As a result, the economic reasons for caveat emptor or buyer beware is so that the buyer exercises due prudence and judgment before actually entering into the transaction. This is covered under information asymmetry mitigation clauses. Now, information asymmetry mitigation clauses sounds like a big deal. It's not really if you break it down. We know that the seller has more information about the good or the shares being sold than the buyer. This is known as information asymmetry. Clauses that mitigate information asymmetry are, well, as follows. First, you can use conditions. Conditions could be precedent, conditions which will have to be met before the transaction takes place. Conditions could be subsequent, conditions that are met after the transactions take place. These could be representations. What facts are true as on the date of the agreement and of the date of closing? Warranties. What facts will be true after the date of closing? In other words, warranties could also be looked upon as promises. Indemnities. For which losses will the company and promoter make good to the investor or the buyer? Now, all of these clauses that come out of information asymmetry mitigation, they all presuppose one thing, that we've already done our diligence. There is no way we can actually draft conditions, reps, warranties, indemnities without studying the asset first, right? Which is why, again, a due diligence to discover risk is absolutely essential. So in other words, information asymmetry mitigation clauses also mitigate risks. The third element of any transaction is to determine how parties will behave with one another after they've entered into a contract. Now, in case of a pure sale agreement, parties will not have anything to do with one another after the actual sale has taken place. But if it's a part sale or if it's a shared issuance, parties will remain as shareholders of the same company. This is covered under post-contract regulation clauses. Now, I have broken down post-contract regulation clauses in a shared issuance transaction into the following three categories. Internal control clauses. These clauses talk about how a company will be controlled partially by the promoter, but there will be checks and balances by the investor as well. This could include the right to nominate a director on the board, the right to ensure that no shareholder or board meetings take place without the representative of the investor being there, the right to ensure that certain matters are not taken up and decided without the affirmative consent or the affirmative vote of the investor, and the right to receive information on a timely basis. These are, in my view, internal contract or internal control clauses. Further, the investor must also take steps to protect his investment. This will include rights to ensure that if there is a second or a third round of investment after this round of investment, that the investor's shareholding percentage remains the same. What we've seen mathematically is that when there is an increase in the paid up share capital, the existing shareholding percentage of all remaining parties get diluted down. To protect oneself against this dilution, you will have anti-dilution clauses. When you're an investor and you're investing into a company, you're doing so not just because you think that the company is worth investing, but also for the able leadership of the promoter. Therefore, if the promoter leaves, there might be an issue with the company. As a result, the investor will require restrictions on share transfers. The investor may also require that if the promoter were to transfer out, that before the promoter transfers out, some preemptive rights are taken place. The promoter may want to ensure that if the investor transfers its shares, it does so in a manner that protects the promoter's control over the company, that the shares are not sold to a competitor. These are covered under preemptive rights. Exit rights determine how the investor will actually exit the company. Now, most investors prefer having a qualified initial public offering as an exit strategy. However, it's not always possible for an IPO to take place in most private companies. Finally, if the company were to go into some kind of liquidity event or some kind of a problem, or maybe even the closure of a project, how will we distribute the remaining value in the company? If the company is to go into liquidation, on what basis will the company distribute its remaining assets? All of these clauses come under investment protection. Finally, we have boilerplate clauses. boilerplate clauses remain pretty much the same across all kinds of transactions. They talk about the fact that this contract does not set up a partnership or an agency, that the parties to the agreement are the only ones that have rights and obligations contained within this agreement, and there can be no other third party. In other words, there is privity of contract. That this particular agreement constitutes the entirety of the understanding between parties, so this is the whole agreement. That parties to this contract are mutually exclusive and they have not entered into similar contracts with other people. That the remedies in this contract are not exhaustive, that parties to the contract may seek out remedies in equity or in law. The contract may be signed in multiple copies, and each copy is considered to be an original and valid one. This is covered under the counterparts. That no party will compete with one another or do anything that will jeopardize the position of the other. This is covered under the non-compete clause. In case a clause in this contract is rendered unenforceable by an act of law, then that particular clause can be severed off and the entire contract itself does not become unenforceable. This is covered under the severability clause. That any waiver of that any non-action taken by a party does not constitute a waiver, and that parties will continue to have the rights in the contract even if they did not act upon them. This is covered under the waiver clause. Parties to the agreement may not assign their rights and responsibilities to other third parties without the consent of the other contracting parties. This is covered under assignment. Parties will have received information that may be confidential about each other. They will not disclose this information to third parties. This is covered under the confidentiality clause. And parties also set up particular addresses where parties can send each other notices. So all of these are boilerplate clauses. When we actually read through one of these agreements later on in the semester, we'll talk about each in considerable detail. The fourth element of any contract is that of exogenous risk and dispute resolution. We've already covered most of the risks involved in any contract. We've covered the risks pertaining to information asymmetry. We've covered the risks pertaining to parties behaving the way they want to or not having any rights or obligations against each other after they've entered into the contract. But if there is any other kind of risk that comes up, a risk that is exogenous, then that is taken care of by a force majeure clause. And finally, if there is a dispute that breaks out between the parties, how will parties to the contract resolve that dispute? What method is to be adopted? Do we go straight into litigation, or do we do arbitration, mediation, or even negotiation? Where will we resolve the dispute? What is the seat of arbitration going to be? And what law will be applicable? Is it going to be the law of the location where the company is located? Or if that's a foreign investor, will it be the law of the location or the jurisdiction where the investor is located? The dispute resolution clause will set all of this up. There is a sixth part, of course, which talks about asset-specific clauses, which again, I'm not going to discuss in this lecture, primarily because it depends upon whatever is being traded, whether it's a car or it's a house or, in our case, shares. Now, this video has been a breakdown of what actually goes into the definitive agreement. We will, of course, be looking at a number of documents and a number of actual clauses that have been used by M&A lawyers in real-life transactions later on. For now, it suffices to say that these 6 elements that have been, that draw from the work of Professor Michael Klausner, these 6 elements form the basis and theory for all transactions, especially share subscription agreements and shareholder agreements.